final document we want to go to, which is the inadmissibility policy, which is to be found in the respondent Court of Appeal bundle. Tab 9 starts at page 156. This is the Home Office guidance on inadmissibility, safe third country cases. And at page 191, within that guidance, it's under the heading in the page before, removal agreements and timescales. And this is talking about circumstances in which removal might not be effected within a reasonable period. And it says the reasonable period may be longer in some circumstances, for example, and then five bullets down, in the middle, right in the middle of page 191, it says where a claimant is referred to the national referral mechanism, it will usually be appropriate to pause inadmissibility action until the consideration of whether or not the person is a victim of modern slavery has been completed. My learned friend relies upon that, but we say that actually supports our position because it provides that if there's a referral, so a referral to the NRM, would usually be appropriate to pause. Not saying it will be appropriate to pause in all cases, it must be paused. So it's not even the case that there's an automatic barrier on removal once there is a referral. Obviously, there's a different 30-day pause for the recovery period when there's a reasonable grounds decision. But this guidance makes clear that there might be circumstances, and we say that must be where there's a good reason why referral to the national referral mechanism, or you can read for that, or a negative reasonable grounds decision before reconsideration shouldn't mean that the inadmissibility action is paused.
May I ask a question?
Yes.
Is there any letter or decision recording a decision not to comply with that usual approach, and if so, giving reasons for it?
No, there isn't.
But the decision, you didn't rely on this, did you?
You mean the NRM decision?
Yes, you didn't say normally we would pause it, but on this occasion, notwithstanding the guidance, we're not pausing it. It says you may not have to.
But they're not responsible for removal. It's it's not within their domain to advise about removal. This is the guidance which applies in terms of inadmissibility and removal.
So that's what my question was directed to. Is there a decision by the Secretary of State saying I've had regard to the guidance and I'm not adopting the usual position because I want to remove this person quickly?
No, there isn't. But we say that's the Secretary of State's position as is being submitted to you.
It may well be the Secretary of State's position now. I'm just trying to understand whether it was ever articulated before this occasion.
No, it wasn't.
Sorry, can you help me because I'm slightly lost? If I've understood the chronology correctly, and I may be out of sync here, the inadmissibility decision was taken some time before the negative reasonable grounds decision.
It was. But this is talking about inadmissibility action, i.e. acting on that decision.
Okay, but
so I think
the inadmissibility decision was taken before the negative reasonable grounds decision.
yes.
Was it taken before or after the referral?
Before.
So it's it's before the referral, I see.
Yes, because there was no suggestion of any trafficking claim until the 14th of September.
Right, so that's the 5th.
So on the 5th...
So the 5th of September, going back to your chronology, is the
Yes.
inadmissibility decision.
Exactly. So serve with a letter saying your asylum claim is inadmissible because you've travelled through a safe third country, France, and you can be safely removed back to that country. And your human rights claim has also been certified as manifestly unfounded. So they get that he gets the inadmissibility decision. He then sees different legal representatives a few days later, I think on the 9th of September. And then it's not till the 14th of September that there's any suggestion of a trafficking.
Well, yeah, you say that, but again, can you just help me understand how this all works? Because I thought that referral had to be by a first responder.
Yes, it was. It was by the Home Office when they got the letter of the 14th of September from the respondent's solicitors.
Right.
So there was so as I understand it, there was a reference to the NRM by a bit of the Home Office. So did the
Yes.
Home Office, once it had received, or once it had made the reference to the NRM, reconsider whether or not it was appropriate to carry on with inadmissibility action?
Well, the Home Office decided it was appropriate to carry on with inadmissibility.
But is there anything recording that decision or recording?
No, there's not. But that's because it was fully expected, as did materialise, that the reasonable grounds decision would be made before removal.
Well, so was it fully expected that it would be a negative reasonable grounds decision?
If it had been positive, we wouldn't have been able to remove.
But the guidance talks about a reference to the NRM, not a decision.
Exactly.
I don't quite understand how this paragraph works. You can't remove somebody if there's a reasonable
Grounds decision.
So if it's referred to the National Referral Mechanism, there is a possibility that there may or may not be a reasonable grounds decision. So are you saying this is consistent with Section 61? And if they ring up on Monday and say, we're going to refer to you, and the Home Secretary says, quick guys, get him out, that's lawful, is it?
I'm not saying that that would be lawful, but I'm saying in this case, we had a negative reasonable grounds.
No, I appreciate that, but that's not what we were talking about. I'm talking about this policy, and I'm trying to understand if somebody has made a referral and there hasn't been a decision yet, which appears to be what this is talking about.
Yes.
Are you telling me that the law is you can remove the person before a decision is made?
Well, it would all depend on the circumstances. Suppose somebody put in a 1-line sentence saying, I was a victim of trafficking 30 years ago, full stop, for example. There might be reasons why, even if that's referred, they might not pause the inadmissibility action, but that would be an extreme case. I mean, I don't think we need to get into this because
This wasn't an extreme
the
case.
practice has been to wait for that decision and get that reasonable grounds decision before removal. But the difficulty is here, removal directions were set. There'd been no hint of a trafficking claim at all. Seen 2 legal representatives, nothing. And then only at the 11th hour is there a suggestion of a trafficking claim once removal directions have been set and a date and a plane has been organised. And at that point, they refer the same day to the NRM, who make a quick decision. They make the decision by the 16th. They take 2 days and they make it.
So in a sense, this doesn't really help at all, this paragraph, then.
Well, what we say is that it actually, contrary to my learned friend's position in her skeleton, it actually supports our argument because it suggests that as a matter of policy, it's usually appropriate to pause the action when there's a referral, but it doesn't say in all circumstances it will be paused.
Then you have to look to see whether you paused it, and you didn't. You said you've got 30 days, you're back to the circles.
But, sorry, can I just be clear, please, just going to that one point. Is there any suggestion that the Secretary of State adverted to this policy before continuing with inadmissibility action after the NRM referral?
I can't show you a document that suggests that the Secretary of State applied her mind to this bit of the policy, no. But it is frequently the case that you get very late submissions to defer removal, whether that's late human rights submissions, asylum submissions. I mean, we had late submissions coming in on the day that the interim relief hearing was heard, and they were quickly dealt with by the Secretary of State. So that does happen.
The
Individuals,
policy could very easily deal with that. The policy could say something like, we'll usually pause once there's been a referral to the NRM, unless that's done at the last minute or something like that.
well, it could, but the fact that it says usually in my submission is enough.
To show that there might be circumstances in which the Secretary of State could.
Good, go ahead.
But the problem that I've got is on this occasion she didn't. She did the opposite. Far from saying we're taking advantage of the fact that this is an unusual case and we're going to act in accordance with the admissibility decision, she decided the opposite. She said you've got 30 days to make a reconsideration request. That's what I don't understand.
That's because, as I've explained, that's the standard response that's sent.
It's
to
not a
people.
response, it's a decision in an individual case. People make an application,
Yeah.
a decision is taken. That is how the world works. And if she decides to use the standard one, she can't turn around and say, well, in fact, I know I promised that, but don't believe a word I say. I mean, it just doesn't work like that, does it?
Well,
Anyway, that's what your case is, it does. That she's entitled to say, well, at the end of the day, you get enough protection in France, and therefore, the fact that she's not going to be reconsidered here doesn't matter. It's effectively your case.
she's entitled to say France are a signatory to ECAT and have domestic provisions in place to protect victims of trafficking. Substantively, his rights are going to be protected if he's removed, and therefore the public imperative to remove people like this swiftly in order to deter more small boat journeys is such that in this particular case it wasn't appropriate to keep going with the reconsideration. It was a weak trafficking claim. We've shown you the detail of the decision. There's compelling reasons why it's been rejected, and it's entirely speculative, we would say at this stage, what's going to happen in the reconsideration, that she's entitled to say, I'm going ahead with removal.
Speculative and pointless to say what's going to happen in the reconsideration, because the reconsideration isn't going to occur.
Well, not on my case, no. But he can go. He can take that trafficking decision. He knows now what the problems are with it, and he can go to the French and say, I am a victim of trafficking. Here's extra evidence. Here's medical evidence.
So it comes down to this, that you say that the public policy objective manifested by the treaty trumps the right to reconsideration which the Secretary of State herself apparently gave the individual in question.
What we say is it's a good reason to depart from the policy.
But
Well, it's not just the policy. I mean, first of all, it's what's in the statutory guidance, which is the Secretary of State's own statutory guidance. Secondly, it's in the very letter
That he got.
that he got from the NRM, which is itself part of the Home Office, saying, we've given you a negative decision, but you have the right to ask for reconsideration within 30 days.
Yes, I accept all of that.
Okay.
There's also a constitutional problem. We've had a revolution about this. The King cannot change the law by the use of the prerogative. The King can't disadvantage people by the use of the prerogative. The King can't say, well, I'm sorry, I don't think 12 years is enough for your offence. It's going to be 14 years. Or normally you can go to the county court, but I don't like you at all. You were very rude to the Queen yesterday, so you're not going to be able to go to the county court. How can you use an exercise of prerogative power to alter the guidance issued pursuant to statute?
Well, what we say is that it's a limited right, to the extent it's a right, for this reconsideration. It doesn't arise from ECAT, it doesn't arise from primary legislation, it's in a policy. And
Which
that
the
there's
common
a good,
law says you're going to have complied with unless there's good reason.
yes,
And how can an exercise on the international plane by the King
because,
change what Parliament has contemplated?
well, because here, what the court is aware of is that you're removing somebody to France. France, we say, can be trusted, we put in the witness statement of Lucy Vaughan, can be trusted to comply with its obligations under ECAT, which is it's a signatory to. It's a tier 1 country in terms of the protection of victims of trafficking. And so what we say is it's a limited procedural right is trumped, yes.
The king can remove in the exercise of his prerogative power.
But in circumstances where substantively this individual will be provided with support as an asylum seeker in France, first of all, and then can ask for additional support as a victim of trafficking. And we say, on the facts of this case, particularly when you look at the strength of the trafficking claim, we say that there isn't a serious issue to be tried. We say further that if this isn't a good reason, then what is? We're not praying in aid a good reason that is obviously flawed or, you know, only has kind of protection in terms of financial consequences. What we say is the good reason is about preventing deaths from occurring now, and deaths that seem inevitable if these small boats carry on. It is, that's clearly the intention behind the treaty, that's clearly the policy objective, and in my submission, that is unimpeachable as a good policy reason.
Can I be just clear about how this fits into the appellate framework? The judge didn't decide that Ms. Naik was correct on this issue. All he held was that there is a serious question to be tried. In other words, that there's a real argument as to who's right and who's wrong on this question of law.
Yes.
I think you accept that you have to show that there's only one answer, namely that she's wrong.
Yes. But then we have our alternative ground 3,
Oh, yes, well,
which is balance of convenience.
well, but how do you get on to balance of convenience unless there's a serious? No, I'm sorry, I withdraw that. Yes, of course. You also rely on this in relation to ground 3, but on ground 1, you have to show there's only one answer.
What we say is that there's a fundamental flaw in the judge's reasoning. That's what we say, and we say that's because he didn't take into account the protections in France that this individual would.
That's the problem. This is a serious issue to be tried. You say there is only one answer to protection in France. The case against you is no, there is not one question. There are 2 questions. The first question is whether, in accordance with the framework and common law expectations and legitimate expectations arising from the letter, he had a right to reconsideration in England, not protection in France, but reconsideration in England. And you have to show it is not arguable. There is no serious issue to be tried. That when you have an Act of Parliament, decision of the Secretary of State, guidance by the Secretary of State, that there's no serious issue to be tried, that can be disregarded because the Secretary of State has got some policy objective that she disagreed with the foreign government. That's your case. And you've got to show that that's an arguable, haven't you, to get home in your ground 1.
Well, we say that once you take into account his position in France when he goes back, we say there isn't a serious issue to be tried. But I'm not. I think we're going around in circles.
Which bit of there's a statutory guidance? He's entitled under the guidance,
We
and he's
accept all
got
of
a
that,
letter.
but we say you can depart from that if there's good reason, and we say that good reason is this policy, is the deterrence, is all of those.
Yeah. Well, can I just rephrase my Lord's question in a slightly different way? I take entirely the fact that you accept that if it were purely a matter of the ordinary domestic law, you accept you wouldn't have a case. But what you say is this is quite different. We're in a new situation here. We have this brand new treaty giving effect to an important government policy. And on one level, that's very easy to understand, but what we're trying to get to a little more clearly is how that operates in law. Because it's one thing to recognise that there's a treaty between the United Kingdom and France, nobody disputes that. It's another thing also to recognise the important public policy considerations that motivate that treaty as are recited within the treaty. That's all fine, and I don't think there's any dispute about any of that. The question is a more legal one, which is, take all of that as read. How does an international treaty, which under well-established principles of UK law, does not have direct effect in our law, it requires implementation by Parliament in one way or another, how does that alter the ordinary rights of a person that they have under English law?
I think what we say is, to the extent they have domestic rights, it's a limited right under a policy. It's not a right that arises from ECAT. It's not a right that arises in primary legislation or secondary legislation. It's a limited right that's given in the policy. And that because of this supervening contradictory policy, which is, no, we don't want them to stay here, we want them quickly removed to France, so that this can act, this whole scheme can act as a deterrent, and we're doing that because their rights are protected in France, and because substantively, it's not just about the treaty, it's the fact that France is an ECAT Tier 1 country.
So
It's a high national policy, we say, and we say, you know, saying it's a treaty that's just binding in international law only is a bit of a red herring. We're saying there's effectively a policy here, as reflected in the treaty, that is unimpeachable in terms of what it's trying to achieve, and that is butting up against this reconsideration. But what we say is there's a good reason to depart from it, particularly when you take into account the facts of this case, it coming so late. They had a chance to put in evidence, the claim is weak.
Right, okay, and then that leads to two final questions on this topic, at least from me. The first is this: would you accept that it's implicit in your argument that the Secretary of State didn't need to change the statutory guidance the following day as she did?
Yes, it must be implicit that she didn't need to. She's done that
So
for
why
the
did she?
avoidance of doubt.
Why did she change it if she didn't need to?
Well, because these removals are happening at pace. These interim relief hearings are happening at a few hours' notice, and it made sense to be clear as to what the position is.
Right.
We say that just because we put that beyond doubt in that change doesn't mean that we're thereby undermining the arguments we put today.
All right. And then the final question on this, which is not relevant to ground 1, but is relevant to ground 3 and perhaps another ground, is this. Are we right in understanding that because the statutory guidance was changed the following day, this particular issue can't affect anybody else, or maybe a tiny handful, but
I think there are others that came earlier that have sought to rely on this, that had decisions made at the same time.
but it must be a tiny handful at most, mustn't it?
I don't know the numbers, but
Can it be a large number? I thought you were only going to do a certain number of people each week in the pilot scheme, and since the 17th of September, when they only started last week, didn't they?
yes.
So were there 20 or 40 cases last week that raised this issue, or is there really, as my lord says, just a handful, if any?
I think there's a limited number. I don't think it's like 20 or 40. I think there were 3 removals last week.
Yeah. Yeah, 3 went ahead.
I just thought, yes.
My lords, my lady, can I turn to ground 3, which
Yep.
is balance of convenience? Even if we're
Can we do
wrong.
Ground 2 as well. Don't forget you've got ground 2, because I don't understand the relevance of ground 2. at the
Yes,
moment.
well, I've already made submissions on that, but what we say is that he does have the right to a judicial review. He can bring that out of country. The treaty protects that. I accept that's not the same as a reconsideration. It's different. It would be looking at errors of law. But a number of the points that my learned friend has raised in her skeleton argument about the points they would want to, make as a matter of reconsideration are also points that could be made in a judicial review.
I understand that, but the key thing surely is that other things that could be done in a reconsideration could not be done in a judicial review, new evidence.
I accept that.
So
But the
Grant
judge, what
doesn't
we
seem
say
to
is the
work.
judge should have taken into account that he did still have that right to judicial review. So if you're saying my account should have met the definition of trafficking, that's a common complaint that you see in judicial review proceedings. and
No,
you see
I
the court
understand
resolve
that. I'm looking at your ground two, Ms. Grange.
Yes,
The failure to take into consideration that a judicial review claim challenging the traffic decision could be brought out of country.
yes.
That was an effective remedy, even if a reconsideration would not be considered. Here, if there's going to be new evidence, by definition, an effective judicial remedy isn't available, is it?
I accept that, but we say that new evidence can go to the French.
That's a different point. It's not your ground two point, is it?
Well, ground two and ground one probably need to be looked at together, because what we're saying is the true situation was he's going back to France where his ECAT rights are protected, tier one country, and he can also maintain a judicial review against the trafficking negative reasonable grounds decision. And that's, we say that does give him some measure of protection.
Can you just help me on the logic of that? I mean, I understand your argument on ground two taken on its own, I think, but I'm a bit puzzled by saying you can take grounds one and two together, because are they not, as it were, a primary case and a secondary case from your perspective? Because your primary case is you're entitled to take the right of reconsideration away for, you say, good policy reasons, strong policy reasons. And if that's right, that's the end of the matter.
Yeah, you could analyse it that way, but I think
And
what we would say
then you don't need ground two.
no, I accept that. But
Ground two only becomes relevant if you're wrong about that. And then your argument is, well, okay, true it is that the right of reconsideration has been taken away, but that doesn't leave respondent without remedy, you say,
Yes.
because
yes,
he can go for judicial review.
yes.
Is
when
that
I say
not the logical
consider-
structure?
Yes, it is. I think that's right. What I was meaning by taking together is that if you're actually considering the concrete situation of this individual, then two things would follow from him being in France. One, he's in a tier one country, which has been recognised as protecting victims of trafficking. And two, the decision that was made here hasn't been consigned to history because he can bring a judicial review of that. So if there's some gross, florid, manifest error on the face of that, it could bring a judicial review, and the court has the power to direct the Secretary of State should use reasonable endeavours to bring him back. That has happened in other cases. And that is, we say that's another reason why there is no serious issue to be tried.
Okay, thank you. And you were about to go on to ground three.
Ground three, balance of convenience. So even if I'm wrong about all of that, and there is a serious issue to be tried, and my learned friend can demonstrate that we're riding roughshod over common law rights, the judge here concluded that when he weighed the balance of convenience, the factors, he said, were finely balanced. And we say that is plainly wrong. You have to compartmentalise the serious issue to be tried and the balance of convenience. You have to start again with balance of convenience. You look at it as an independent question. We submit that if we're right about the respondent's position, when he goes back to France, his rights are adequately protected there. He has not lost his underlying substantive right to receive protection as a victim of trafficking, if that's what he can establish. And we say the factors in his favour, in one view, amount to little more than a preference for protection in the UK. He will get accommodation and support as an asylum seeker, and he can also claim support as a victim of trafficking. So this is not an individual who is being sent back in the face of a real risk of Article 3 ill treatment.
It's nothing to do with Article 3 of treatment. It is trafficking.
Of course, but my lord, what the reason I say that is because if I was standing here and the position was that there was a real risk that he would suffer Article 3 ill treatment
Yeah,
in
but
France,
the judgment's in your favour on Article 3, and
Exactly.
there's no respondent's notice on that, or
precisely. And therefore, what is the risk to him? Well, it's that he doesn't get his reconsideration of his trafficking claim, but he is a person who, when in France, can assert his rights under ECAT and ask for additional protection.
At page 153 of the respondent's bundle, the judgment sets out everything that he considers. And he says there's a serious issue, the claim is with respect to the trafficking decision. He then goes on to say there are lots of weighty reasons as to why this person should be removed and why the Secretary of State's policy should be taken into account. And he says at the end of the day, on balance, given the interest of the claimant versus the wider public interest, he thinks it's reasonable to do part of what you yourself promised and give 14 days for representations instead of 30. So why is that an exercise of discretion that is so unreasonable, so perverse, or involves a wrong approach of principle that this court should intervene?
Well, what we rely upon in particular was him saying that the factors are evenly balanced. Do you see that?
I see that,
In that.
and you've got to read the whole of it, and he comes back to that and saying the precautionary principle. You think it's far more important that this person goes back. We've had, I forget how many tens of thousands we've had, and you're saying it's really important, not that we just send the 3 back that we sent last week, or that we send more this week, now that we've got the policy change. You're saying it's really important that anyone who crosses our doors and we say should go back, irrespective of any serious issue to be tried.
Well,
And the judge says, no, I don't agree with that, actually. I'm taking a more moderate approach. You promised 30 days. I'll give him 14 in the first instance. Why is that an unlawful exercise of discretion on the part of the court?
well, we say that him saying that they were finely balanced was plainly wrong, because when you analyse his position, being as a person being sent back to France and what he's losing out on, but also you've got to look at what his position will be in France when you're doing that balance. This is also someone who can be brought back. Article 9 of the treaty, there's a provision in there that makes clear that if a court so orders it, that France will facilitate the return of the individual. What we say is you simply can't weigh up the policy imperatives on the other side of that balance and decide that they are evenly balanced. Because, sorry.
One policy argument is that the Secretary of State has made provision for a proper investigation of trafficking cases.
I accept that.
Two, she's so concerned about that she says we're going to give you 30 days because 3, if we got it wrong in the 24 hours when we were rushing this decision through, we will send you back when you're guaranteed 30 days of protection in this country. And why isn't that a weighty policy consideration, equally with the weighty policy consideration to send people back to France?
My lord, I'm not saying that's not an important policy consideration, but I am saying that in the context of this policy, when people are dying
That's
in
a
the
little bit
channel,
extreme.
every
Nobody's suggesting the judge has condemned people to death here. It's
I'm
trying
not,
to
I'm not,
balance
I'm not
up
suggesting that.
sending this person back
My lord, I'm not
or giving
suggesting
him
that.
14 days, and that's all the judge has done is given him 14 days.
My lord, I'm not suggesting that. But every time a removal does not happen, the ability of this policy to act as a deterrent effect is eroded.
So it's pour encourager les autres, yes?
Sorry, I didn't hear that.
Pour encourager les autres, yes? And how does that work in circumstances where the policy, the guidance, the statutory guidance, was changed the very next day? So for everybody else who follows, they're in a different situation.
They are. Yes, I accept that.
So
But that
how
doesn't-
does the decision on this individual case on the previous version of the guidance, how is that relevant to deterrence of those who come subsequently?
Well, because we would say that every time it's clear that an individual they're having their time extended and extended and extended.
Well, this individual, by decision of the judge, has had his time chopped down from 30 days to 14. That's hardly an extension, is it?
Well, my lord, I think they're now suggesting that they're not going to be able to do it within the 14 days and that they're likely to need more time in order to...
Well, that will be a subsequent decision for whichever judge that comes in front of, as to whether that's justified.
It will, but what we say is every time that happens, even in an individual case, just one individual case, that is affecting the extent to which this policy is doing what it's intended to do, which is act as a deterrent.
So is the submission this, that the success or failure of the current policy depends on a decision on an individual case when the relevant statutory guidance has been changed the day after?
I can't put it that high. No, I can't say the whole policy will fall. But what I'm saying is I don't think you should underestimate the extent to which when decisions are made which allow more time, particularly in circumstances where this individual didn't raise this until the 11th hour.
No more time has been allowed. Less time has been allowed by the court. You decided.
Well, more time has been allowed than the 17th of September, which is when he was scheduled to leave on a plane.
Yes, because you did on the 16th, he had 30 days.
Yes, I accept that. I accept that.
We aren't extending anything. You've given him 30 days and this judge cut it down. The problem.
Yeah.
My lords, my lady, we say you can't
I mean, it comes down to this,
In an
the
objective-
public interest trumps everything else.
here, I don't say it trumps everything else. This is not an individual who is alleging that they were trafficked through France. This is not someone who says, I'm a sex worker and I've been trafficked through France and I'm here. This is someone whose trafficking claim is one stage removed from that. They are going to get support in France. There is no
Sorry,
question
can you help
of
me
them.
on the relevance of that? I mean,
Well, it's relevant
because
you've got to
under
look at-
ECAT, the location of the trafficking is immaterial, isn't it?
What I'm saying is, if this was an individual who was alleging that, for example, those that arranged her journey through France were trafficking her, who she feared from in France, that might be a different type of case to this one. But when you stand and look at the cold hard facts of this individual's situation, if returned to France, what's going to be lost? That's what the exercise you've got to do. What's going to be lost if he's returned to France?
Compliance with the rule of law and taking away the rights of individuals. That's what will be lost.
That's one way of looking at it, but I'm submitting that's not the right way of looking at it, my lord. What I'm submitting is that there's no suggestion that this individual won't be provided with support, with accommodation, in a country where he can raise the complaints that he's made. And that to try and describe that as of equal weight to the public policy considerations that arise behind this policy, we say is simply wrong.
The public policy considerations about swift return and not even reconsideration, on the 17th of September, that's the position. So we're really looking at a small group of people in the early days of the policy when you might think perhaps the Secretary just screwed up and she got it wrong and forgot to change the policy. Well, that's her choice. She hasn't explained why she had the policy as it was. She doesn't explain why she hasn't changed it. But in terms of the impact on the public policy, as my lord said, after the 17th of December, or whenever it was, September, there will be no public interest adverse effect as a result of the ability to have decisions reconsidered. So that's gone. We're looking at a small group of people where you yourself have said you should have 30 days, and if the decision has changed, you won't be removed. And you're saying, we don't care about that. We still want it sent back, because even one person managing to avoid the treaty policy as opposed to the statutory guidance policy is going to unravel the entire thing.
Yes, we are saying, and I said it at the beginning, there is some real urgency to this because of the point that we're at in terms of the weather will turn, it will get colder, the chances of people perishing start to increase. And so there is a real timeline here in terms of
this
delivering
is the
policy.
aspect that we're questioning you about. I mean, we're not questioning the policy, of course. The question is, what is the impact of the decision in this particular case, given the change in the statutory guidance the day after? And when you talk about the weather getting worse, there seems to be a disconnect there, because the weather getting worse will affect those to whom the new policy, the new statutory guidance applies. And therefore this problem for the Secretary of State won't exist because the statutory guidance has been changed.
My submission is that you have to look at the decision the judge made that day on whether to grant interim relief. And he said that the two considerations were of equal weight. We say that that's obviously wrong, and that it's clear that the public policy imperative behind this policy would outweigh what this particular individual was at risk of experiencing or being deprived of.
Yeah, well, I think we've debated that sufficiently.
Yes.
What about? I'm sorry. Does my lady have a question?
Yes, I'm so sorry. Can I just get back to the question which my Lord Justice Lewis asked you a moment ago? I just want to understand whether you accept the premise of that question. Do you accept that what has happened in this case amounts to a failure to comply with the rule of law and a decision which has deprived this claimant of the rights he would otherwise have had?
No, my primary case is no.
Right,
We
so you
don't accept
the
that
premise of
because
that
we
question.
Because that's your ground one.
That's my ground one. But what I'm
But
saying
we
is
assume by
even-
this stage you've lost on ground
assume
one.
I've lost, and you say that was contrary to the rule of law.
Yeah.
There's a common law right to this reconsideration. You've clearly given it him, and you can't curtail it. And he's got a prima facie case or serious issue to be tried over that issue. What I'm saying is that it was then wrong for the judge to say that the balance of convenience was evenly balanced.
Even though on one side of the balance, on the judge's analysis, you've got a serious issue to be tried about whether this person has been treated lawfully in this country.
Yes.
Okay. I just wanted to
yes.
flush that out.
Yes, because you have to look at what they are being deprived of and the consequences of that.
I've understood all of that.
Yeah.
I just want to
Yeah.
understand the.
And you have to look at their concrete situation if removed.
Okay.
So if we decide that you're right on this and the judge was wrong to say evenly balanced, we then have to exercise the discretion ourselves. And what if we came to a similar decision for different reasons? What if I said there's a very, very strong, you said very weighty thing here. We want to save these people from drowning. We want to smash the smugglers model. And we hope the government will succeed with the policies got in place from the 17th of September. But on balance, that doesn't justify taking away that which they promised to this particular individual. Would we be able to reason it like that? Or would that in itself be subject to the Supreme Court saying, no, you got that wrong too, mate?
My lord, I think you could decide to decide the issue yourself. I don't see why you couldn't do that, rather than remitting it back.
Could we reach a decision similar to the judge without it being unlawful? Or is it only one decision that can be reached?
Well, I think we're saying it's quite hard. These are the type of public policy considerations that it's quite hard to see how those would be outweighed or counterbalanced. I would accept if there was a risk of Article 3 ill treatment for an individual, we might be in a different place. I'm not conceding that point, but I'm saying, but we're not there. But what I'm saying is it's quite difficult to see, given the concrete situation of this individual, how those public policy considerations couldn't outweigh it. That's how I put it.
Right. So your submission is that in truth there was only one exercise of discretion that was open to the judge.
On the particular facts of this particular case.
Yeah.
Before I forget, can I just ask a question about the notes of the hearing that were provided by the respondent solicitor? Page 151 of the respondent. I just want to understand whether there was any discussion between you and Miss. I never know whether it's Miss Nike or Miss Nake.
Miss Nike.
Between you and Miss Nike about how, if the claimant was to be given more time, how long that should be. Now, the reason I ask that is because the second big paragraph down from the top of page 151, Miss Nike is recorded as saying KG says a week. I just want to understand what that means, and it may be that you can't help me with that. It's not your note.
So, just by way of context, this came at the
Sure.
end of a 3-hour
No,
interim
no,
relief
I
And
understand all of that.
it-
You know,
it-
we've been
everyone was
in
very-
similar
yeah,
situations.
everyone
so,
was
you know,
extremely tired
No,
by
no,
this point.
absolutely got that.
I can't remember whether that's what was raised quite quickly was that Miss Nike was wanting the time to be able to get a medical report for her client, and I think at this point we were discussing how long for a medical report was necessary.
Right, just in the abstract.
Well, I honestly can't recall.
All right, well that's very fair.
I don't think Miss Knight can recall either. She's shaking her head. I'm sorry.
All right, no, that's fine. I just wanted to see whether we could get any help from that.
Yeah, I think it's time we got on to ground 4, please.
Yes, I can be brief about this one. So we say that 14 days was too long, in essence.
Well, can you
We
help
say
me?
it's
Can I?
excessive.
This is the relevance of my lady's question,
Yes.
because as discussed previously, the statutory guidance says 30 days. The decision letter from the NRM says 30 days. So on the face of it, the judge has chopped the time into less than half of that provided by the statutory guidance and by the decision letter.
Yes.
And that's in circumstances where the respondent has said, we are trying to get more evidence, in particular medical evidence, and that's plainly going to get time. In fact, they're also trying to get other evidence as well. How on earth can you say that 14 days is outside the bounds of any reasonable exercise of discretion?
Well, my lord, the way we put it is to say that he failed to give appropriate weight to certain key factors. The lateness of the trafficking claim, and when it was made, it hadn't been made at the asylum screening interview or in the days thereafter, despite receipt of legal advice. The obvious weakness of the trafficking claim as set out in the decision. The fact that further information was sought and provided. All of these factors.
Well, look,
we
if the respondent is not entitled to reconsideration at all, for the reasons you've advanced on grounds 1 and 2, then this
falls away.
This all falls away.
Yeah.
So we're proceeding on the premise here that the respondent is entitled to reconsideration in this country, and the only question is how long
Yes.
that they have to put in any further evidence.
Yes.
And so what is your submission is 14 days is too long. So what would be the minimum that you would say was
Well, we say
the
40
maximum?
We say 48 hours.
And are you seriously submitting that a medical report can be obtained and is submitted within 48 hours?
Well, what we said was that if you look at the trafficking decision, as we have done, the medical report was one of a very, very long list of problems with that decision. And we therefore said that the judge... I beg pardon?
Well, look, that would make one think that a fortiori, 48 hours isn't going to be enough. There's a long list of problems and he's been given the
Yeah, so
opportunity.
what I meant by that was that there were fundamental problems with the account. A lack of detail had been provided. He hadn't provided it earlier.
Yeah, no, we understand.
You've got all of those points.
Yeah.
And what we were saying was, or what we are saying is that public interest factors in favour of a swift removal meant that 14 days, we say, was too long. It's a short point.
I've got
a good point or it's not.
I've got a different difficulty with your ground. You say if it is denied there was to be interim relief, it should have been for no more than 48 hours to permit the respondent to provide instructions to his legal representative and make his request for reconsideration. with any further evidence to follow. But I thought your whole case is you're not going to allow any further evidence in once you've gone to trial. So I don't understand your ground at the moment.
You're right about that. We wouldn't be able to put in further evidence to follow once he's
40
left.
hours can't be
Once
enough
he's
then.
left the UK.
Your
Well,
40 hours is predicated
think
on
what we
him
were
putting the
suggest-
evidence in later.
what
and
we
you
were
can't.
suggesting was that, in fact, what he needed to do in terms of this decision was not obtain medical evidence, was deal with the more fundamental problems, including a lack of detail.
So let me be clear. What you're now submitting is that the judge should have refused the respondent the opportunity of submitting medical evidence,
Yes.
right? And why would that be lawful?
Well, we say because looking at the context of this particular decision, the lateness of the claim, the weakness of it,
So let me be.
and the public
Let me
policy
try and understand that
imperative.
further. I think what you're now saying is that the request for reconsideration is bound to fail. And if that's the basis of the submission, then why is any further time at all justified?
Lord, I'm not saying it's bound to fail. I'm saying
In which
it's
case,
got-
if it's not bound to fail, then the respondent has to be given a reasonable time to submit further evidence, doesn't he?
Yes, and then the question is, what's reasonable on the facts of this case? I accept that. And we say,
30 days in your letter. Why isn't that a good starting point? So if you depart from 30 days for a lesser period of 14, it can't be said to be irrational. You must have been doubly irrational to say 30 days in the first place. It doesn't make sense. You see my problem, Miss Graham?
yes, I do.
Yes.
I do. I do.
All right.
Anyway,
What we also said was that that kind of delay risks being extended and extended and extended. And what we would say is that if you look at the witness statement of Mr Robinson that's been put in on behalf of the respondent, they're now saying that time period is unlikely to be sufficient. They've asked for lots of extra disclosure.
that's for the
They're
judge. the next judge.
instructing another expert, not just a medical expert. And so it goes on.
That's for the next judge, isn't it? We're only being asked to deal with an appeal against the order saying 14
Yes, I mean,
days.
and the next decision may be to deny the respondent any further time.
It might. It might. But we
Yep.
say, looking at all of those factors, 14 days was just too long.
All right, very good. Well, thank you for your patience with our questions.
One more thing. You asked whether France is a dualist system or not, or
Yeah.
a monist system. We understand that France is a monist system, meaning that international treaties do form part of domestic law, and in some cases are supreme over domestic law. However, we're not aware of the specific national law rules on whether an individual in the situation of this individual would be able to bring a claim, such as under Article 4.1c of the UK-France Treaty. It would take us some time to
Investigate that.
bottom that out.
All right, well, that's very
We've
helpful.
done our best.
Thank you very much. That's appreciated. So, as I was saying, we're thankful for your patience in answering the many questions that you've had from the bench. The fact you've sat down suggests to me that you've said everything you wish to say, but can I have confirmation that you have indeed said
I have.
everything you
Thank
wish to
you.
say? Very good. Well, I think we will rise to consider what to do next.
All rise if able.
Back up at the front is spare.
Oh yes, sorry. That was his name, I've forgotten.
All rise, people.
Miss Knight, we needn't trouble you. Having carefully considered both prior to and during the course of the hearing the submissions made on behalf of the Secretary of State, we have decided to refuse permission to appeal against the judge's decision. Full reasons will be provided for our decision in writing in due course. But in very brief summary at this stage, we have concluded that the judge made no error of law or principle in making the decision that he did. Accordingly, none of the four grounds of appeal are sufficiently arguable to have any real prospect of success. In particular, with regard to the key ground, ground one, we are satisfied that the judge was correct to hold that there was a serious issue to be tried on the question of whether the Secretary of State was acting unlawfully as a matter of English law in removing the respondent in circumstances which were inconsistent with the Secretary of State's own statutory guidance and the express terms of the letter from the national referral mechanism, both of which give the person affected the right to request reconsideration of a negative reasonable grounds decision within a period of 30 days. As the professionals in court will know, the way in which the written reasons for our decision will be dealt with is that once the drafting of the reasons have been completed, the draft judgments will be supplied to counsel under embargo for the purposes of checking typographical errors and ensuring that our account of the facts of the case does not, through inadvertence, enter into some error, but not for the purposes of re-arguing the case. If you would be so kind as to supply a list of typographical and other errors for our consideration, we would be grateful. Once we have considered the list of errors and finalised the judgments will be handed down digitally in the usual way and will be put on the National Archives website, and no further attendance will be required. Now, given the nature of our decision, I would hope that we can deal with any consequential matters here and now. And so, Ms. Nike, I think in the first instance, it's for me to ask you if you have any application to make.
Well, we have an application just in respect to our costs of the appeal in responding to that.
The application for permission.
To appeal, apologies, and I do say that we had to put in a significant amount of resources to respond to the appeal because a significant number of very broad arguments were raised that went maybe said to them.
Let's deal with the principle first of all. Can you resist an order for costs?
I don't think I can. We would just ask for costs to be assessed if not agreed.
Are you asking for anything more than a detailed assessment on the standard basis?
No, I don't think so. No.
Very good. We will order the appellant to pay the respondent's costs of the application to be assessed subject to detailed assessment on the standard basis.
Well, the only other application, sorry, in respect of costs is that we should, in the usual way, seek a 50% payment on account within 28 days of service of the day. It's the usual order. Unless there's any
of costs. You don't know what 50% is.
upon service of the bill. Well, I can't. I'm afraid I can't give my lord a
So,
figure.
if you put in a bid for 5 million, you get 2.5.
It's not a blank checkbook. I think was the phrase. There's a form of words. Yes, I apologise, but it's not obviously an open. But perhaps we can negotiate. Perhaps we can discuss that with.
Why don't you discuss that, and hopefully you can reach agreement. If not, we can decide that matter on paper.
Okay.
All right. Is there anything else on either side? No. Thank you all very much indeed for your assistance.
All rise in favour.
So much work.
So many.
I thought you were brilliant.
Yeah, thanks. I do think I was very good.
It's one of your finest hours in court. Talking about problems.